So good morning, everybody. Thanks for joining us this morning. I am Katie Ruckel, the state's Chief Privacy Officer, and today's webinar from the Office of Privacy and Data Protection is on privacy notices. So I know that's not the most exciting topic, I think, but it is a fundamental piece of privacy in the United States and how we work with privacy in the United States. So today, an overview of what we're going to be talking about is why privacy notices are important. And then we'll get into the differences between privacy notices and privacy policies, how they relate to the Washington State Agency privacy principles, what should be included in a privacy notice, and we'll touch on some of the controversy around privacy notices, and then some things to keep in mind with your privacy notices. So we'll go ahead and get started. So privacy, the importance and relevance of privacy notices are, they are definitely on the minds of our lawmakers in Washington. So these are examples of recent legislation this past legislative session. These past couple of legislations sessions for the 21-22 sessions. One was the what we called the COVID Health Data Protection Act from Representative Slatter. And then we had another one from Representative Banky regarding state agencies collecting personal data. We've also had the People's Privacy Act that actually required Commerce to do model privacy policies. And then we also had consumer data privacy bills. I only listed one here, but all of them required some sort of notice. So quickly, I'm just talking about these legislations or these bills just because I think they really do demonstrate what is on the minds of lawmakers. And it helps to show that this bill actually did pass. It ended up getting vetoed by the governor for other reasons. It wasn't because of the privacy notice, though. And so this would have actually required notices to talk about an organization's data retention and security policies. And then, of course, some of the standard parts of a notice, which is, the reasons you're collecting the data, who's receiving it, and how individuals can exercise their rights. And 1552, this one was specifically targeting state agencies for making sure that you are being transparent and accountable, which are two of our privacy principles. And then also talked about identifying the purposes for sharing data. So these are just two recent examples, and I expect that we will see more. This is an actual clip art of the requirements that were in, or sorry, a clip of the language in the bill that for the requirements. So there are actual federal laws that require notices, and all of us are familiar with these notices because we receive them frequently in our daily lives. So that would be for HIPAA and for healthcare, the GLBA, which is the Gramm-Leach-Bliley Act. It just came up the other day for financial purposes in a meeting I was in, and then FERPA, which covers notices for the educational sector. So quickly, I'm just going to go over some of the requirements for the HIPAA Notice of Privacy Practices. This is a very general highlight. It has way more details in the actual law, and all of our HIPAA covered entities are well aware of these requirements. But I would say HIPAA was really one of the first ones that came out with models and examples of how to do a privacy policy. And I do have some links to that information, but it highlights the theme that you'll see of what's required in privacy notices, and which includes, how individuals can exercise their rights, maybe how to file a complaint, who to contact as well. So the GLBA privacy notices is much more extensive, and many of us are familiar with this in our personal lives, because if you have bank accounts or credit cards, you get these paper notices mailed to you. I think it's required annually. And so I'm not sure how many people spend time reading those privacy notices or wondering why you get all this extra paper in the mail all the time, but that is the reason it's required to be mailed to you in paper form. And this is the law that requires that. The last federal law that I wanted to mention is FERPA, and it's not called a privacy notice, it's called an annual notification of rights. And this is to inform the public, and especially parents or guardians, about what their rights are in terms of their students' educational records, how to get amendments to those records, which is also something that's in HIPAA, how to provide written consent before the school discloses PII. There are exceptions for the directory information, and you probably see some of that language if you have children that are part of in the education system. And then also how to file a complaint is also part of the required notices. So the last reason to care about meeting privacy notices is it actually is required for those state agencies that are subject to the jurisdiction of the governor. In Executive Order 1601, Governor Inslee signed an executive order that actually requires state agencies to review and update privacy policies to match the current information collected and retention procedures, and that the policies need to be prominently displayed on every agency's website, homepage, and any other page where personal information is collected and reviewable. So for many of us are relying on those website notices, and Matt's going to talk about some of the differences, which is our next section. So what is the difference?
What is the difference? Good morning, everybody. Hope you're all doing well today. So we're going to talk a little bit about the difference between a privacy notice and privacy policy. Next slide, please. So just to start with the basic definition. So a privacy notice is just a comprehensive notice that explains how an agency collects, uses, shares, and manages personal information, while a website privacy notice is a more limited notice that isn't contemplating all the ways you may gather information. It's really just explaining what information is collected when you visit a website and how that information is used, shared, and managed. So if you were a company that solely does business online, the website privacy notice might be all you have. But for us in state government, we collect information in lots of other ways. In person, we collect hard copies of information, and we get it from other sources and other agencies. So we really do need something that's a little bit more comprehensive. And then the last one up here is privacy policy, which is the internal documentation of an agency's commitment to how it collects, uses, shares, and manages personal information, and the expectations for staff that it has set. So the reason we're spending time on this is because there is a little bit of confusion about these three terms, partially because they're often used interchangeably. So you may hear a privacy notice called a privacy statement or a privacy policy or a notice of privacy practices. For website privacy notices, you may hear them called a cookie notice or a security notice, but you can also hear or see just privacy notice, privacy statement, privacy policy. And then for the privacy policies, those internal documents themselves. So those internal privacy policies can also be called something like a privacy plan, privacy code of conduct, and privacy practices. So I did a little bit of research on this just to see what other organizations are using. And just as an example, Google says privacy policy, Microsoft says privacy statement, Amazon says privacy notice, and they're all talking about the same external document. So not saying that Google and Microsoft are wrong and Amazon is right. but it's helpful, just as we all talk with each other, to have a common language, and at least to try within this group of government folks. I think it's helpful to try to, as much as possible, break it up into these buckets and use these terms for consistency. And just again, to highlight that the basic difference is that the privacy notice and the website privacy notice are more closely associated with transparency, because they're talking about how we communicate with external audiences, while the privacy policy is more focused on accountability and how we hold ourselves to those commitments, and it's more of an internal facing document. Next slide. So in our annual privacy assessment of state agencies, we ask them questions about these notices. And this is the data from the last 2 years, so 2020 and 2021. So the number of agencies that indicated they have website privacy notices stayed pretty consistent. It was 51 in 2020 and 50 in 2021. And even though those are almost the same, it probably actually indicates a little bit of a decrease, because we had more agencies respond in 2021 than 2020. Going on is that people are starting to have a better understanding of the difference between these two types of privacy notices. So that is a little bit of a blip in the data, but we think that in the long term, this is a good change. Next slide. Agencies that have internal policies. So again, just drawing that distinction between the external notices and the internal policies. And I know the writing's a little small here, but this is showing the 7 Washington State agency privacy principles that we have, and how many agencies have a policy that addresses each one.
Yes.
Okay, sorry.
I don't know if that was me or Everett. So I assume we're on to this.
Yeah, I think it was just Matt.
Oh, okay. So next, Matt's going to talk about our relationship between privacy notices and privacy principles.
Okay. So I touched on this a little bit in that last section, but I just wanted to call out that these privacy notices are really closely tied to our Washington State agency privacy principles. So we have a transparency and accountability principle, and the transparency part is about being open and transparent about what personal information is collected, for what purposes, and who is shared with. Next slide. And when we're implementing it, we're very explicitly talking about these types of notices. So providing clear, honest, and open communications about what information is collected, how it's used, and who it is shared with. Next slide. And it's also tied to accountability, meaning being responsible and answerable for following data privacy laws and principles, but especially is tied to, or accountability is even more closely tied to those privacy policies that are internal facing. So go to the next slide. So we're talking here about the internal reflection of how you're going to carry out the commitments that you've publicly made. And then these notices in general are intended to really encompass all of the privacy principles. You know, they reflect why you're gathering information, they reflect who you're sharing it with, which gets to due diligence, but we wanted to specifically call out individual participation, meaning giving people control of their information when possible, because the privacy notice is really how you tell people that they have these rights and how they exercise them. So how they can access their information, how they can correct it if that's appropriate, and those types of things. So I think that is the end of the privacy principles section. I'm going to turn it back to Katie to talk about what should be in a privacy notice.
Thanks, Matt. So there is no perfect privacy notice, just like there's no sort of silver bullet for the data share agreements when we talked about different templates and models for that. And so there's several elements that should be included. And in some of the laws I talked about earlier, they are pretty prescriptive on what needs to be in a privacy notice. And so while this list is not exhaustive, it pretty much hits the highlights of really what you should be thinking about when you are creating your privacy notices, and the best way to make sure that it's comprehensive and transparent for the individuals whose information you're collecting. But the other piece, and this gets to the accountability principle that Matt was talking about, is that it also helps the organization and employees understand how to treat information and what the expectations are for the organization. So first, you should, identify yourself, who is the organization. Several of the privacy notice talk about types or categories of personal data collected. So the categories are typically things like if you're collecting health information, calling that out, or if you're collecting demographic information, calling that out as a category of information. It's not necessary to have every data element you're collecting, but at least explain the broad categories of the personal data. And then getting into how the personal data will be used, how it will be shared. For GDPR especially, even though we're not subject to that for most state agencies, it is important under that law, though, to talk about where personal data is being used or stored, for example, if it's going out of country. And even if that's not required necessarily for your organization to identify that, I would encourage you to try and maybe understand where the data you're collecting is used and stored, just for your own information, because that might also that might help the way you want to explain things in your privacy notice in terms of how the organization is using personal data. Also, how long you're keeping the data. I think retention policies and data minimization is also important here, in terms of Matt talking about some of the other privacy principles that are reflected in the privacy notice. I think stating how long you're keeping it can also help agencies stick to retention policies and getting rid of data when they no longer need it. So how personal data is protected. I know that is a sticky issue sometimes, because security people get concerned about maybe unveiling too many security practices that could make them vulnerable to attack. But there were a couple privacy notices, I think, in the COVID bill that talked about specifically identifying security procedures. And so I think those things can be touched on generally, like encryption as a practice, those types of things, in terms of of how an organization is protecting data. And then what rights a person may have in regard to their use of the data. This is specifically required, especially in the federal laws, about what informing individuals regarding their rights on data use. And then the contact information for who at the organization people can contact to ask questions about the privacy notice, or even possibly make a complaint. So some of the laws like HIPAA and FERPA specifically require you to provide contact information for who to make a complaint to. And when I was privacy officer at DSHS, I received those complaints, and my information was also posted in our hospitals. So that it wasn't my name, it was privacy officer, but for the patients to be able to make complaints to me. And I did receive complaints directly from patients regarding some of the data handling practices at the institutions. And then also, this is a right in HIPAA, and so I've put, if applicable, rights to withdraw consent and sort of how to withdraw consent. There's sort of a trend right now where they're talking about, the right to withdraw consent or opt out should be as easy as opting in or giving consent. There's been some talk about organizations not being as transparent to allow people to opt out. And so this is part of the dialogue, I think, with some of the laws that are being discussed right now, is that making it easy for consumers to opt in and opt out or withdraw their consent. Of course, that doesn't mean that if an organization has already relied on consent to do something, that they would be held responsible for anything that they were legally allowed to rely on that consent for. But at some point, if there's a withdrawal of consent, then you need to make sure you have all of the practices in place to be able to honor that person's wishes. And this kind of comes along with, I think you see it in the healthcare sector, especially when you allow your information to be shared with an individual. Sometimes partners no longer want to share certain information with certain people, and so they want to withdraw who can see that information. And so that's a typical example of withdrawing consent. And then I think the effective date, or at least the last date that the notice was updated, is important as well. It's good for, I think, the entity to keep in mind. The privacy notices should be updated, I think, at least every 5 years, or at least reviewed every 5 years, to make sure that they're still accurate. I had the opportunity to review something recently, and I think it was last updated in 2003, and it had citations to old laws that no longer existed in Washington. So that's a good reason to make sure that you're sort of dusting off those notices and making sure they're up to date and accurate. So there are lots of examples out there of privacy notices and model templates. And as I noted on that slide, the list that I put together is not exhaustive, but there are model templates. HIPAA, the one for HIPAA is, in my opinion, it's very complicated, and that's going to be a pretty select group of people that have to worry about those model notices. The FERPA notices I found to be a little more user-friendly, and I think probably the most user-friendly template when I was reviewing for this presentation was the GLBA model form, although those end up being the longest, but I think when we get those in the mail. But these are all resources available from the federal government, and so these are all federal websites that we have linked here. So in terms of other resources, so in our research, we came across a website from the United Kingdom's Information Commissioner's Office. And this was extremely comprehensive, and of course, more sort of, I think, in line with the GDPR. But the piece about this website that I thought was very useful was that, and I don't expect you to be able to read this, right? The list on the side was that it had very long checklists. And so even if some of those items may not be required in privacy notices in the state of Washington, it was very comprehensive. And so I thought if you're interested in sort of digging into what other things you might think about including, because I made the note that the list is not exhaustive, this is the website for the Information Commissioner's Office. So recommended best practices, what you'll hear frequently is that layered privacy notices are what is recommended. And these are privacy notices that are, the layered approach came about because it was responding to problems of excessively long privacy notices. So this way is sort of recommends having a short notice, so a short statement. You may see these too, especially when you're doing something on your phone and you're filling out a form, and they might have the little I button for more information, and you click on that, and maybe I'm one of the only people that does this because I'm a privacy professional, but it says, like, why are we collecting this information, or what are we going to use this for? And then there's just a little short sentence that says, you know, we may need to contact you about your shipping or something like that, or why do why you need your phone number or something like that. So those are the short notices, but then to get the longer notice or the more complete notice, you can click on that and it will give you all of the information about the intricacies of the privacy practices of a particular organization. So that's how the layered is supposed to work. And I just did a couple of screen grabs of examples of the layered privacy notices as well. This is one from Twilio, and also I don't expect you to be able to read this, but the point is that it sort of has a content section, and then you can click on the link, and then it will take you down to a more complete explanation of what the organization is doing with the data. And then this was another example that I found regarding what we do with your information. So this is more from like a phone, and then you can click on those and then read more extensively about what is happening with the information, or you can complain to, or those types of things. So this is just also a call out to demonstrate the connection too between, well, this is the NIST privacy framework, but between security and privacy in terms of, this is a partial list of some of the subcategories that are most relevant in the NIST privacy framework, which talks about the function of communicating processes and being transparent. And so this privacy notices and policies are a part of what's expected under the NIST privacy framework as well. And then under 853, there's also privacy notice control, which talks about making sure that individuals are notified about how their personally identifiable information is being processed. You know, it even includes in 853 identifying the authority that authorizes the processing of the personally identifiable information, which isn't one I put on the list, but is something that we do have called out specifically in the lawful, fair and responsible use principle, which requires you to think about, you know, what is your legal authority for collecting the data and processing it. So there's a lot to talk about in terms of the privacy notice debate. And so Matt is going to fill us in on some of the controversies around privacy notices.
Yes, and we're going to take a little bit of a step back and talk about kind of the more academic and policy side of privacy notices and how we got here. So we haven't always had this emphasis on privacy notices. Back in 1998, less than 5% of websites had privacy notices, and I think that's actually really high. I read in one place that it was actually about 2% of websites that had privacy notices. But then just 3 years later, in 2001, virtually all prominent websites had privacy notices. And today we know that virtually all organizations in all industries have privacy notices, regardless of whether they are covering online or offline activities. So how did we get here? So we need to, again, take a little step back. It's starting with fair information practice principles, which have been around since the 70s and had a principle of openness about how you're using information, which is the predecessor of our Washington State Agency transparency privacy principle. So the idea has been around for a long time. But then in the early 90s, I think it was 1991, where the internet came into our homes. And all of this started to change, and the ability to collect information changed as well. So shortly after we started using the internet, we started having banner ads. Then in the mid to late 90s, we had the advent of targeted searches and search engines like Google. And then building on that, we started seeing around that same time period from the previous slide, around 1999, we started seeing pay for placement advertising and pay per click advertising, which required more detailed tracking and collection of information. And then around the mid 2000s or so, with the new prevalence of Facebook and other similar sites, we started seeing targeted advertising that has only continued to blossom since then. Next slide. So during this period of rapid expansion in the late 90s, especially, some of these practices started to get really annoying. I imagine that we all have memories of trying to click on a website and getting 20 pop-ups and spending 5 minutes reducing or closing out boxes to read an article for 2 minutes. So with all this happening, there also started to be a lot of scrutiny on these new practices on the World Wide Web. And the industry responded in part by starting to adopt privacy notices as a way to try to preempt new laws by demonstrating that the industry could police itself and that they could protect consumers by self-regulating and telling them about what they were doing and giving them some kind of choice was one vehicle to do that. Next slide. And in many ways, that attempt to show that they didn't need to be regulated was successful. So we have started to see new privacy laws around the US and certainly internationally that do place an emphasis on privacy notices, as Katie talked about earlier, that they're no longer just a best practice. In many cases, they are actually required. But even in the absence of laws for industries that aren't regulated, this has still kind of become the main paradigm for how we think about privacy. And even when we do have those privacy laws, they're largely based on the same concept of what's called notice and consent, or sometimes called notice and choice, which is really just the simple idea that an organization provides notice of how it's going to collect, use, and share information, and then the individual consents or chooses to agree and go forward using the product or service. Next slide. But the problem and the I guess debate that Katie alluded to is there really choice? Is there really consent? And is it really enforceable? So when we're talking about choice, it's really getting at the issue of, do you actually have the ability to shop around? Saying there's a choice suggests that there are multiple options to choose from. But there's been so much consolidation in the tech industry that in reality, you probably have very few options for most things. There's some really good reporting from Kashmir Hill at the New York Times and some other folks in the tech reporting area where they've tried to actually live a private online life using only alternative kind of privacy preserving websites and applications and trying to avoid services from the bigger tech companies. And the conclusion uniformly has pretty much been that you can't do it without significant disruption and hassle for yourself and the people you're trying to interact with. So in practice, it's not really a matter of being able to choose services that don't collect information. There's not really that choice. The choice that you have is really more about whether you're going to participate in online activities or not. In terms of whether there's really consent, so and Katie mentioned the long notices that we all get. When the GDPR was updated recently, can't remember if it went into effect, the new notice requirements in 2018 or 2019. We all were barraged with emails notifying us of the change of service and asking for our consent for their new practices. And it's led to consent fatigue, where we all get so many news that we rarely read them. If we do, we probably don't understand them. So there's a real question about whether we're actually consenting to these practices or we're just deleting emails to get them out of our inbox or clicking through terms and pop-ups just to get to the service that we're trying to access. And then in terms of enforceability, so going back to when these started being a thing in the late 90s, that was also around the time that there were lots of other like click-through agreements and click wrap of terms and service coming up. And those are all considered enforceable contracts, and that was the point of them. And so the early thought was that privacy notices were also going to be an enforceable contract, but that's not really how it played out. That's not how they've been treated by the courts. There hasn't been a lot of judicial activity or litigation around this. So for the most part, they're just treated as a statement from the company that an individual can't actually enforce when it's violated. But the one big caveat there is that the Federal Trade Commission has general authority to take action against companies that engage in unfair or deceptive acts and practices. And if a company makes a misleading or false statement in its privacy notice, then it's pretty easy for the FTC to allege that it engaged in a deceptive practice by lying to the consumer. And in practice, we've also seen that that is, in fact, the basis of many FTC privacy enforcement actions. So this debate is very well publicized. People have noticed and criticized whether this notice and consent regime actually works. And that includes more recently, or very recently, more scrutiny from the Federal Trade Commission. So just a couple of weeks ago at the IAPP Global Privacy Summit in DC, the Federal Trade Commission Chair Lena Khan spoke about privacy enforcement for the first time in detail. And she commented that basically this industry seems to incentivize endless tracking and vacuuming up users' data. And about notice and consent said, "I'm concerned that the present market realities may render the notice and consent paradigm outdated and insufficient. Focusing on notice and consent ends up sidestepping more fundamental questions about whether certain types of data collection and processing should be permitted in the first place." So I think to people that have been paying attention to this wasn't necessarily a surprise, but it definitely sent some shockwaves about possibly where the FTC may be heading with enforcement action going forward. Next slide. So what would it look like to go beyond notice and consent? So one option is moving towards a harm-based approach, where instead of looking explicitly just at what was promised to the consumer, you look at how the person may have been harmed by something that happened. And really related to that is the idea of moving from deceptive enforcement to enforcement of unfair actions. So I mentioned that FTC can enforce against deceptive or unfair practices. And so for unfair practice, they won't necessarily have to violate a statement in a privacy notice or other promise to the consumer. Instead, the basic test there is whether there's a substantial injury that's not reasonably avoidable and not outweighed by countervailing benefits. So it allows a little bit more subjectivity into looking at the harm that is caused to a person. And then the last one on here is about setting baseline protection. So the idea, just like Lena Khan had said from the previous slide, that you may need to set some rules for basic things that shouldn't be allowed at all, or put some guardrails around certain practices. And that could come from FTC rulemaking, or it could come from congressional action. And we have seen things like that in legislative action already. I think HIPAA is actually one example where it lays out a lot of rules about things that you can and can't do, and allows those things to happen to keep the industry flowing, but then requires that anything beyond that requires consent. In Washington State, we've definitely seen it in many of the bills that Katie referenced at the beginning of this presentation around either prohibiting or setting specific rules around things like facial recognition, or automated decision-making, or setting specific rules if you're doing something that's going to result in profiling. So this is all still in flux, and we'll wait to see what happens. I do want to point out, though, that even though this is probably going to change in all likelihood, that there may be some movement on this, that the idea of providing a privacy notice and being transparent as a way to demonstrate trust isn't going to go away. And is going to continue to be something that we should all care about and do as part of our jobs for state and local government. I'll turn it back to you, Katie.
Thanks, Matt. So that brings us to things to keep in mind. So even though there is controversy or questions about how well privacy notices work and the consent model works, we still need to be putting forward our privacy notices and making sure that they are clear. So it is true that privacy notices mean something and they are required. So things to think about in order to keep your privacy notices up to date is, as I mentioned earlier, to review them periodically, and then update the notices to reflect the current data use practices. I think we've seen several examples, and this has come through in some of the FTC enforcement that Matt was alluding to, where companies put forward notices and then didn't actually follow the practices that they said they were doing, and then that is what got them into trouble. And the same can happen to state agencies, even if we're not under the FTC jurisdiction. You can be held accountable for not doing things that you say that you're doing. And so the other piece of that is to make sure that the teams know what are in the notices if they're responsible for data handling practices. You don't want to put something in a notice and then not communicate it to those that are expected to be following those practices within the organization. The other piece, and this is highlighted in several of the bills and legislation, is to use plain language and avoid legalese. And that is because the point of privacy notices is for average people to be able to read and understand what is happening with their data. So other things to think about is how you're delivering your privacy notices. One of the, I think, gripes, I guess I would say, about the GLBA is I think it actually requires the notices to be delivered by mail. And at the time that was written, that made sense, but it's less sort of relevant now. But because of it being in the law, you know, we get all these paper notices every year because it's required to be delivered by mail. That's where there's a little bit of an advantage with HIPAA, which is by rule, and the rules can be changed easier than the laws can be changed. So that's sort of that gets into the law versus rule debate in terms of how prescriptive you want to be in a law, because you are going to be held to that until the law can be changed. Many laws allow for online notice, and that's how most of us are providing notice. However, if a consumer asks for written notice, at least under HIPAA, you are required to send it by mail. And then also thinking about the timing of delivery, when a person can see the notice. I think you've seen, if you've been on websites, especially websites that California residents may be visiting, we're getting lots of pop-ups now about cookies and accepting cookies and all those types of things. And we didn't really get into the cookie and ad tracking piece of things. That's kind of a whole nother topic, but thinking about when you're delivering them. And I did do some research on this, and it is pretty much expected practice now, because everybody sort of has learned that the privacy notices are going to be linked to at the bottom of websites, and that's where people expect to see them. So that's a acceptable way to do that. So, and then as I said, everybody should be making sure you're following what you're saying in the notice, because you can be held accountable for those things. So there's one more slide, and Matt's going to talk about kind of an interesting tool we learned about.
Yeah, so I think a good way to sum up what Katie was just talking about is to say what you do and do what you say. And one interesting way to verify that is with this tool from the Markup, which is a tech reporting outlet. And they have this tool called Blacklight that lets you put in a website, and it will search it to see what kind of tracking they're doing and what kind of cookies they're using, and whether there are third-party cookies on there. So this is, I think, a kind of fun way to verify if your privacy notice is accurate, if you're really doing what you say you're doing, and then also even in our personal lives to see what kind of information is out there being collected. So I would encourage everybody to take a look and check this out. And that is the end of the presentation today. I haven't seen questions coming into the chat, but is there anything anybody would like to ask now?